You cannot. 21 incident reports since January 25th of this year.
A 17-year-old defendant, 2 felony charges, and a second chance hanging by a thread. This isn't just another day in court. This is a legal powder keg ready to explode. Christopher Bushnell came in with plea deals that could have spared him from prison, but his own actions inside jail are about to shatter that lifeline. We're talking 21 separate incident reports, from fighting to bullying, all while the judge is watching every move. Today, you'll see a judge push back hard, reject plea deals on the spot, and lay down a brutal warning that could mean decades behind bars. Pay close attention, because what happens in this courtroom could change this young man's life forever. And trust me, you're going to want to hear exactly how it all unravels.
So, Mr. Bushnell, you were previously in court, entered pleas of guilty to the third-degree felony offense of evading arrest or detention with the use of a vehicle, and the second-degree felony offense of engaging in organized criminal activity. Those were for agreements of a 10-year probation deferred in each of those cases. I have received the pre-sentence report. Has everyone had an opportunity to review that report?
Yes, Your Honor.
Are there any additions or corrections to the report?
Just that it may indicate that he doesn't take full responsibility, but after speaking with him, he does take full responsibility for his actions and involvement in both cases.
I've also reviewed jail incident reports. Have you both been given a copy of those?
Yes, Your Honor. I have.
So you're 17 now?
Yes, ma'am.
I don't think he turns 18 until
December 26th.
And Judge, if we need to go back and renegotiate an offer, obviously he's not even out of custody yet, and this is how he's acting.
Well, and
Your Honor, obviously due to his age, I want him to have the opportunity to get his life together, obviously not going into adulthood with felony convictions. I have preached to him the importance of following the rules and not...
you can't do it, can you?
The number that just came out of the judge's mouth, 21 incident reports, is staggering. For context, in most county jails, even 2 or 3 major write-ups during pretrial detention can tank your credibility in front of a judge. But 21? That's practically a flashing neon sign saying, I can't follow rules. And here's the kicker, these aren't minor infractions. We're talking fighting, stealing, bullying, behaviors that scream instability and defiance. The judge's logic is simple. If you can't behave in a controlled environment like jail, why would anyone believe you can succeed on probation in the real world? This is where the tide starts turning hard against the defendant.
You cannot. 21 incident reports since January 25th of this year. 21. Fighting, calling officers names, stealing food, instigating fights, being a bully to other people in the dorm. Ridiculous. So if you can't follow rules in the jail, what makes you think you're going to come in here and I'm going to say, sure, go be on probation out in our community? After y'all shotgun, I mean, this is serious. I'm tired of the shootings. I'm tired of people, you could have killed somebody. And because you accidentally didn't kill somebody, you get to get a probation. Not today. If I could send you to ISF, I would consider it. I can't. At this point, I'm going to reject the plea agreements. We will set the cases.
What just happened here is legally significant. By rejecting the plea agreements, the judge is effectively wiping out any guarantee of a lighter sentence. In Texas, a deferred probation offer for a second-degree felony is a lifeline. It means no felony conviction if completed successfully. But that offer's gone now, replaced with the very real possibility of trial, where juries can hand down up to 20 years for these charges. This isn't the judge being cruel, it's the judge saying, I'm not rewarding bad behavior. And with every write-up on his jail record, the defense's bargaining power shrinks to almost nothing.
For a review in about 30 days. Let's see where we are, go over his options, y'all talk. If I can always do, upfront time, but we've got to get to a certain point where that would make sense. And so at this time, I'm just going to reset the cases. Again, I'm rejecting these plea agreements. And let me tell you, you get more of these, it's only going to get worse. I'm going to see them. A jury's probably going to see them a jury will see them if you go to trial. And you're going to end up in prison for up to 20 years because you can't follow the rules in our jail and you're acting like a little punk. So go stop acting like a punk, prove that you can behave, then we'll see what happens. When you come back next, I'll see how many of these I have. Go back with the bailiff. All right, you're Christopher Bushnell. And so Mr. Bushnell has two cases, an evading arrest or detention with a motor vehicle and engaging in organized criminal activity, and cause numbers 25-0112 and 0113. There was previously an agreement, and a plea agreement for 10-year deferred probation. We were here because of the issues in the jail. I rejected that because if I were going to go along with that, I was going to order the ISF. And so we're back here. And then, so let me ask you, I should tell you what's bad is when I remember stuff, Mr. Bushnell. Your birthday's in October, right? No, December. So we're getting close, but here's the problem, Mr. Bushnell. So you were here May 6th, right? And I didn't accept these plea agreements, and I got pretty upset with you because of what had been going on in jail, right? And what did I tell you? You know how many write-ups you've gotten since May 6th?
The defendant's answer here, too many to count, is devastating in the eyes of the court. It's a mix of sarcasm and resignation, and judges pick up on that instantly. In legal terms, attitude can be as damaging as the facts. When a judge feels you're not taking their orders seriously, they stop seeing you as a candidate for rehabilitation and start seeing you as a public safety risk. Viewers, let me ask you, if you were the judge, would this kind of flippant attitude make you more or less likely to give probation? Drop your thoughts in the comments, because this moment could be the nail in the coffin for his case.
You want to take a guess? Too many to count. Too many to count. May 6th, you got, since then, 1, 2, 3, 4, 5, 6, 7, 8, 9, 10, 11. 11 more. Fighting, same things. Fighting, not following the rules, calling names. I mean, same thing. You don't like following rules, do you?
I do.
You do? What part of calling a correctional officer the names that you've been calling is appropriate?
It's not.
It's not. So why would you keep doing it after I told you? I told you, go just be good for a month. 1 month, be good, follow the rules. And it's one thing if you've got another inmate running up on you fighting and that was your excuse, but it's not. I'm not accepting any plea agreements. If a jury wants to see all this and give you probation after that, that's going to be up to them. I'm not doing it. Go back with the bailiff. We'll set your case for, well, let me do this. Ms. Holmes, has been appointed as your attorney, and she's one of the attorneys who handles a lot of cases for me as a court-appointed attorney.
This is a moment that often gets overlooked in courtroom dramas, the defense attorney's position. Court-appointed or not, lawyers work hard to negotiate deals that protect their clients, but they need cooperation. The judge is blunt here, the defendants making the lawyer's job almost impossible. In real-world practice, when a client keeps racking up misconduct reports, it not only weakens the case but can also sour the working relationship with their own legal counsel. And you can hear it in the judge's tone. This isn't just about the law anymore, it's about respect, accountability, and whether the court believes this defendant is even willing to help himself.
What I can do is release her and appoint a new attorney who can begin preparation for trial. Do you want me to do that? Or do you want to keep Ms. Holmes? All right, Ms. Holmes, get ready for trial. And let me tell you what you're doing. You're making her job hard. She's trying to help you. I wanted to try to help you. If you came in today and didn't have all this nonsense, I'm looking at it over and over, calling them the B word, not doing what you're supposed to, saying, I don't care, write me up, I don't care. If you don't care, then I don't care. Because I tried last time when we had this conversation. So your case is going on the trial docket, and again, we'll let a jury decide what to do with you. Go back with the bailiff.
So, here's where we land. Christopher Bushnell came in with 2 serious felony charges and a deal that could have spared him from a permanent conviction. But repeated misconduct inside jail, from fights to verbal abuse toward officers, convinced the judge to reject probation outright. Instead, this case is now heading toward trial, where a jury will have the final say, and the stakes couldn't be higher, up to 20 years in prison. This case is a textbook example of how courtroom leniency can vanish when a defendant shows a pattern of defiance. If you found this breakdown as intense as we did, hit that like button, share your thoughts below, and don't forget to subscribe for more jaw-dropping courtroom moments. Trust me, you won't want to miss what's coming next.